Hi, everyone. I'm Leyza Blanco, a shareholder at Sequor Law in Miami, Florida, and I'm presently serving as chair of IWIRC this year. I practice as a specialist in chasing down assets and information in worldwide fraud matters, and I use insolvency as a powerful tool to do that. Today, I'm joined by several of my colleagues who are also in the insolvency field, practicing in different areas throughout the world. So I'll introduce them briefly, but I first want to welcome you to the Women at the Forefront of Insolvency series. This is the first of our series, and I want to welcome everyone on behalf of both IWIRC and III. And I wanted to give you some of the details of the logistics for these sessions so that everyone has the information regarding CLE and other logistics. First, as a part of these series, attendees can attend any of the sessions throughout the symposium that they would like. And even though you didn't pre-register, you're welcome to attend any of the sessions. The materials and the bios for the speakers for each of the sessions are found on the symposium website link that you received for each of our panels during this week. And a CLE and CPE code will be posted in the attendee chat function about halfway through each of the presentations. This is the code that you'll need when you're applying for CLE and CPE for the sessions that you attend. Finally, a CLE CPE instruction email will be emailed to you with a brief survey after each of the sessions, so look out for that email. All the sessions are being recorded and they will be posted on the IWIRC YouTube channel in the next couple of weeks. So if you miss any that you would like to attend, you can feel free to access them at the YouTube channel. Pending time constraints, if there are any questions, you can feel free to use the attendee chat function and the questions will be passed on to your moderators. And if time allows, they will be addressed by the panelists. So with that, I'll introduce my colleagues today. I am joined today by Kristina, a director at KPMG LLP in the UK and licensed insolvency practitioner. Kristina is presently serving as co-treasurer of the London network. Kristina specializes in contentious insolvency, asset tracing, and recovery in the UK and overseas, and has experience in all types of corporate and personal insolvency procedures, court-appointed receiverships, investigations, recovery and enforcement of assignments, private client and family disputes in which insolvent deceased estates are involved. And Kristina is known for her pragmatic approach, which ensures effective strategies are developed and implemented to maximize realizations. Next on the panel, we have Margot MacInnis, who is a managing partner of Grant Thornton Specialist Services, leading their restructuring and insolvency practice in the Cayman Islands. Margot is passionate about insolvency and asset recovery work, and she enjoys a tough challenge. She's an established court-appointed liquidator and has obtained foreign representative status on a number of high-profile cross-border engagements, including the estate of Pelletier, China Medical, Platinum Partners, to name a few. Finally, last but not least, is Flávia Millard. Flávia is a lawyer and a manager at Paoli and Balbino, Barros in Brazil, in the state of Minas Gerais, and she's presently serving as vice chair of the IWIRC Brazil network. Flávia has served as a trustee in insolvency cases, including the MMX cross-border insolvency and fraud matter. She is involved in assisting judges in improving insolvency procedures in Brazil in order to ensure that everyone leaves the process better than when they entered it. Thank you, ladies, for joining us today on this discussion regarding when in Rome, the different aspects of serving as a fiduciary in different parts of the world. So with that, we'll start our discussion. First, Kristina, describe the role of a trustee or liquidator in your jurisdiction.
Yes, so I should just say to start with, good evening, everyone. Here in London, it's actually evening, so whichever time zone you're in, I'm very pleased to be speaking here today. And yes, to the question, so the role of a trustee and liquidator. In England and Wales, we're appointed under the Insolvency Act 1986 and the Insolvency England and Wales Rules 2016. And our appointments deal with the company or the individual's affairs, and we preserve and realise assets for the benefit of creditors. And liquidators are appointed over corporates, so over companies, and there are different types of liquidations. As the first I'll explain is a compulsory or winding up by the court. And this is where a creditor petitions for a company to be wound up, and if the court is satisfied, will make a winding up order. The official receiver here is then appointed, and creditors can nominate to appoint their preferred liquidator, and there's a process to follow for that. The court can also appoint a provisional liquidator, and that appointment can be made to secure and preserve assets. And that's where there's been a creditor petition and before the winding up order has been made. So in that period, to make sure there's protection of assets. A creditor's voluntary liquidation is another insolvency procedure where the members or shareholders resolve for the company to be placed into liquidation. There's then a creditors meeting who ratify the appointment of the liquidator. And then finally, the final liquidation, members voluntary liquidation, and that's a solvent liquidation for the orderly wind down of a company. And the directors have to issue a declaration of solvency that the debts of the company will be met within 12 months. So moving on to a trustee in bankruptcy, and this is an appointment over individuals over here. And so this is where an individual can apply to the adjudicator for their own bankruptcy, or a creditor can petition for the bankruptcy of the individual. So that's very similar to winding up by the court in the corporate sense. So all the assets and liabilities vest in the bankruptcy estate, and it is for the trustee in bankruptcy to administer the estate and again realise assets. We also have a fixed charge or Land and Property Act receiver, and they're appointed by a secure creditor under their charge to realise a specific asset. And so that's the role over here.
Margot, tell me about the role in Cayman. Is it similar?
Yeah, well, it is. In Cayman, much of our legislation emanates out of the UK. So Kristina did such a good job covering the types of tools and processes that maybe it makes sense for me to just highlight the way some of them, I guess, are used in practice in Cayman to achieve a result. And certainly we see more often here probably provisional liquidations because it's our light touch restructuring or insolvency. And in Cayman, there was a move kind of just at the start of COVID to amend the legislation to bring in the powers of appointing a restructuring officer, so that would give us a clear tool for being able to appoint a restructuring officer and achieve a true restructuring. I think with the provisional liquidation, it is used in that capacity, but it also has some controversial aspects to it, in the sense that it could be abused if a creditor were looking to cause trouble for management to achieve a result, or management abusing their powers and processes to get something past a creditor. So it certainly is a tool that the courts need to look at very carefully in terms of is there a legitimate restructuring plan and process before they put a company into provisional. The other thing we use quite a bit in Cayman is a receiver. So given the nature of global structures and Cayman's prevalence in those kinds of offshore holding structures where it sits at the top level holding company, you'll often find receivers appointed to shares or over specific assets. I think Cayman's a jurisdiction where a lot of lenders use a Cayman vehicle to lend money into a structure because they can rely on the law and the judiciary, and so it's heavily used in circumstances like that, which then in distressed scenarios lends itself to having a receiver appointed so that they can hold the ring while a dispute is worked out between two sides. So those are some kind of key distinctions in terms of Cayman versus UK. We also have the solvent liquidation, and sometimes that can be used obviously to where there's parts of a structure that need to be wound down and there's still if it's solvent, you don't need a court-appointed liquidator. They can wind up certain assets while keeping others going, provided it stays solvent. Sometimes where it's doubtful, you'll find that the shareholder can resolve to put it into liquidation, and then the liquidator can seek to be supervised by the court. So you get the same sort of cover as an official liquidation, where you have the reporting obligations and the statutory provisions attached to your appointment as well. So
excellent. Flávia, tell us a little bit about how it works in Brazil under the Brazilian law.
First of all, I would like to say that I'm grateful for taking part in this event, besides such incredible, renowned women. And of course, talking about the appointment of trustee and liquidator in Brazil. First of all, there is no provision liquidator in Brazil. And in Brazil, we won't use the word liquidator for insolvency proceeding. We only use this name in administrative proceedings for banks and insurance companies. And after the administrative proceeding, they will undergo the same court order proceeding that you use for other companies. So we will have a trustee appointed. And we also don't have receiverships or personal bankruptcy. Bankruptcy in Brazil is applicable only for corporation or limited liability partnership. In Brazil, there is a private trustee appointed in both cases, liquidation and reorganization. Our bankruptcy code is from 2005, and we had last year some huge modifications in December 2020. This new law that modify our code entered into force in January 2021. And this law sets for the trustee roles in liquidation and reorganization. There's no specific requirement to be appointed as a trustee. However, the federal law determines that the trustee needs to be a reputable professional. He can be an economist, an attorney, a business administrator, or even a legal entity specialized in those areas. And liquidation, the trustee is the legal representative of the bankruptcy estate. And reorganization, the trustee oversees the procedure in general, having a lot of duties and roles. And I believe that its main role is to oversee the procedure and report his accomplishment to the judge.
Excellent, thank you. So Margot, can you tell me a little bit about the powers of either trustees or liquidators in Cayman?
I can. I'm on a Marvel binge, so it's making me think of the Avengers. So I suppose in terms of which powers we use, sometimes you need the Iron Man level nuclear option where you have to move to an official liquidation to deal with the challenges ahead if there's a real need to compel discovery and examination of third parties to get the information you need. And there are other times where maybe more Black Widow strategy is necessary to kind of get in there in a stealth way and find some of the threads to chase down the assets. So the circumstances of the challenge that the clients are facing, whether that's an investor in a fund and the investment manager is ghosting you and you can't get any information and any reports on your position, or maybe you're a lender and the super yacht you just loaned the money into the structure is now sailing to Panama and you're not sure what the next steps are. So certainly if depending on the corporate structure and what you need to do and what you know would dictate whether you're using your official liquidation superpower or you're using a receivership or maybe even ordinary types of litigation to bring about some information and discovery.
How about in England or in the United Kingdom, Kristina?
Yeah, so as Margot describes the strategy, it's obviously very important because every case is different. But in terms of some of the key steps, here will be the gathering the books and records, which will be similar, I know, for Cayman as well. But it's really interesting, the information you can gather, and not everyone always realises that in insolvency. So it will be the accountants, the solicitors, it will be solicitors from a number of years ago, and you just sometimes need to find that one bank account that's mentioned on a client ledger that can suddenly just open up a whole case. Also interviewing the directors, the bankrupts, other persons as well. And we'd normally record those interviews, and over time you'll be maybe interviewing again, and then you can look back quite easily about what's been said and if there's any contradictions. It can just crossovers, and that's very effective power. And there's also challenging antecedents transactions. So we have specific transactions that can be brought onto the Insolvency Act. So for example, transactions at undervalue. So that's where an asset has been gifted or not enough consideration has been paid for an asset. So you can bring a claim to restore the position to what it would have been. Another example is a preference. So where a creditor has been, if they're owed £1 million, and then 2 months before they suddenly receive that repayment. Another one can be a director repaying their personal guarantee, preferring themselves ahead of other creditors, so they're in a better position on insolvency than they would have been. And claims against directors for misfeasance, breach of fiduciary duty, and that's quite a broad claim. That would be common to bring in our world of the contentious insolvency and asset recovery. Fraudulent and wrongful trading. So if a company has traded when they were insolvent or ought to have known they were insolvent, a claim can be brought for the loss that has been suffered by creditors for the change in the assets. And a transaction to defraud creditors is a powerful claim because that doesn't actually have any time limits. So whilst transaction value preferences, depending on the procedure, in terms of corporate or personal insolvency, there's different time limits, but transactions defraud creditors, there is no time limit that you can go back on. So very powerful.
So the transactions to defraud creditors, is that the name of the action has no limitations, no statute of limitations?
No, you have to look back to actually what was the purpose of the transaction. So often a reason might be given, say a property is given to someone and a trust is created over a property, say in 2005, for example. If it's shown that that was for tax reasons and it was legitimate tax advice, then you wouldn't. But if you can see that there's insolvency at the time, there's difficulties, you could go back that far.
Excellent.
That's where your methodical approach to finding the records, like you say, and getting the bank account that has the details, so that you can start to pick away some of those threads of a plot that's usually started years before, or maybe even only months before. But
there's definitely some similarities to the U.S. processes, but definitely that's one important difference is most of our fraudulent transfer preference actions, we call them avoidance actions, do have limitations, as do other types of actions that are applicable in insolvencies but are available under state law. So that's very interesting. How about in Brazil, Flávia? What are the important powers or tools you have there?
There are different roles for reorganization and liquidation. In reorganization, the trustee decides the first challenge between debtor and creditors and prepares a list of creditors to present to the judge. He calls the creditor meeting to vote the plan and to decide other issues related to reorganization. He can also request the conversion of the reorganization into liquidation, which it's a real power. It happens in the event of default of the reorganization plan, or if the debtor is not complying with the plan, when they can also request the conversion of the reorganization into liquidation. In liquidation, the trustee is the legal representative of the state, so he can hire experts after judge approval always and file lawsuits against the company owners or managers if they committed wrongdoing or fraud during their management. He also controls and collects the assets of the state and the documents, and he have to file lawsuits to protect and to defend the state's interests. The trustee is also responsible to sell the assets and pay creditors following the legal order that we have in our bankruptcy law. Before the modifications in our bankruptcy law, there was no term for the trustee to sell the assets. But now the trustee has 60 days to present a plan to sell the assets and 180 days to implement this plan and to sell the assets. And this term seems to be enough, but it isn't, because the trustee needs to implement acts like to evaluate the assets and to issue for the creditors and other third parties the bidding notice of the sale of the assets. And all these acts are official court acts. So I will, as a trustee, I will depend on the judge order to do this. And it's most of the times, I believe we won't have enough time to do so.
Well, was that time frame that was provided in the new law, can that be extended, or is that a definitive time frame?
We don't know how the judge will deal with this in our new law, but I believe that the judges have to see each case to see if it is possible or no to give more time to sell the assets. I believe they will consider the case and the assets, of course, to see if you can have more time or no.
Flávia, when did your law officially go effective?
Last January 2021.
So it's been in place only about 3 months?
Yes.
Or 2 months almost?
Yeah.
Okay. Excellent. Okay, so then let's talk about what your biggest challenges are serving as a liquidator or other professional fiduciary in your jurisdiction. Kristina, let's start with you. Can you tell me what presents the biggest challenge when you're serving in these roles?
Yeah, I think one of the challenges can be how the extended period that an insolvency can last, especially where there's assets in different jurisdictions. So it's a challenge to keep the key stakeholders sort of focused on the end game, which is to maximise recoveries, and as well as managing those expectations and the costs as well and timeline. I think the strategy is key to manage that challenge and making sure you bring together the experience and an expert team. So you focus on areas, and we've spoken about strategy already, but for example, realising the more readily realisable assets to start with, and perhaps using the funds from those or some of the funds from those to then look at different aspects of the case. And regular reporting is of course important to stakeholders, so they're fully aware of what's happening. You show your commitment and that obviously you're making sensible choices, and it just keeps the mind focused as well.
How long can a case go? I mean, what's the longest you know of?
It's like, how long is a piece of string? Yeah, I mean, I think it really does depend, but we would be looking, because we talked about time limits earlier, and there are time limits.
Are your cases old enough to drink? Are they like 21 years old, or are they?
Yeah, no, not that old. I mean, some may be for some, but no. I'd say if you go all the way to court, then it could take, say, 6 years from start to beginning. But it depends on how difficult the claim is. It depends if you have settlement, which can happen in these cases as well. It just really depends on the number of jurisdictions. But that's a good question.
It's one of those
Margot.
questions nobody ever wants to answer, kind of like how painful is childbirth?
Well, it's a good way to compare, right? So if a case in the UK can last a long time, you know, as long as a string, or about 6 years or so, how would that how would that work in under Cayman law in Cayman, Margot? How long can a case last?
I mean, Cayman has a benefit of being at the forefront of a number of really active, high-profile insolvencies. I'm thinking, you know, when I first came to the island, I had the privilege of working on Bank of Credit and Commerce International, which was at that time the largest insolvency worldwide. It was the world's global bank, and I think that went on to 20 years. So when I started, I could say I had the privilege. I think near the end, I don't think anyone was admitting to how long it had been going on, but you know, you just can't wind up some of these structures. I think you look at Lehman and how long that's taking, and not through the fault of the process. It's just the steps you have to take to recover the assets. You have to be patient. And I suppose from Cayman, the challenge always is the tension between the need for information and what you need to find out to develop a really coherent, solid, efficient strategy for recovering the funds versus your need for control over those assets and trying to get the information as quickly as possible. And it's always changing. I'm struck in, you know, 20 plus years in this business. Every call starts out the same. People think they know what's happened and they think they know who's involved and where to go. And 3 months into it, it's just an entirely different ball game. So, and to Kristina's point, those things when as the information is becoming available, your team has to be nimble and creative enough to react to it, to keep it efficient and keep it on track. Otherwise, you have clients who are terrified about the costs building up or the timeline. So it's certainly an industry for people who have the skill and experience to navigate it.
And the nerves,
I
right?
was thinking about challenges and listening to Flavia's the introduction of new legislation, which is super exciting. But I also, it's also must be hard to be sat there not knowing how some of it will play out. I know that's happened in Cayman when they've brought in amendments. It makes it more challenging to be able to predict the outcome.
Yeah, we know you have this new law, and you probably can't answer questions presented in the new legislation with certainty. So that's a challenge. What other challenges do you find in your jurisdiction serving as a trustee?
Talking about time, there's a big challenge in Brazil, which is the time proceedings take to get a final judgment, of course. And we face this every day. Our systems allows numerous possibilities of appeals and create an environment of uncertainty. These decisions can be revealed, and it makes people involved very concerned about it, especially when these decisions has to be recognized in other countries as a foreign procedure. And we have this problem here. Besides, coming back that I was talking about in the selling assets, the new law implements a penalty. If the trustee didn't sell the assets during the term, he can be removed from his position. And he also won't be able to work as a trustee for the next 5 years. And it's very challenging, of course. We don't know, like I said, we don't know yet how courts will construe this new rule. But it's something that trustees have to pay huge attention to as of now. And it's a challenge we face. Another one, I guess, is the liability that trustees may hold. They may be held liable for losses to the state and to the debtor or creditors for volunteer breach of their responsibilities. And of course, they will be held responsible if they breach their obligations, but they will also be held responsible if they sell assets below the market price, and they can be challenged not only by the creditors, but they can be challenged by the debtor, the creditor, the prosecutor, and other interest part. And talking again about the new law, it changed a little bit, because now there's no talking about injurious price anymore. The law cut it off. So, but trustee needs to put the assets for sale, of course, at a market price. And we, like I said, we don't know how courts will construe this new rule, but I believe that now that will get better. I guess this is our challenges in Brazil.
Thank you, thank you. So as you maneuver through these challenges, can you tell me how you think about selecting counsel in your cases? Do you match the counsel to the case? How does it work, Margot?
I think we probably look at two things, maybe three, but certainly in terms of priority, I'd consider the size and complexity of the matter. So what is it involved? What type of industry, jurisdictions? How big is it, so that you have a sense of what's going to be required, and then you obviously want to match that to the depth and experience of the team you approach. I mean, if it were a largely Cayman-based matter, there are people who have a lot of experience across all industries in Cayman. If it's something that's going to be cross-border, and maybe it's going to require relationships in a number of other jurisdictions, those factors come into it, and then I think a lot of people would say there's the long haul flight test in terms of and unfortunately for most of us, we haven't had the pleasure of traveling on long haul flights for business in a long time, but maybe it's the Zoom call test of, could you do 10 Zoom calls in a row with that person on a case? So I think there is definitely the human relationship factor of you want to enjoy what you do, and you want to enjoy working with people who are focused on giving great results and putting their all into a case. So I think for us, those are the factors we look at.
Any additional factors that you consider, Kristina?
Yeah, I think, I mean, echo what Margot says there. And I also think there'll be sector specialisms as well. There may be specific sector focuses that certain barrister chambers or individuals may have as well. So that is a key consideration. I just thought I'd pick up on the Zoom point, actually. And here last year, when obviously COVID hit everyone here in the UK, we were pleasantly very surprised and found that the courts didn't actually have delays for too long caused by it. And the judges embraced Zoom calls. And so it'd be interesting, I think, as hopefully we come out of COVID, how much of the long haul flights will be there, or will it now be more acceptable to have even experts only or smaller hearings actually virtually? It's interesting times ahead, and I think we have to look ahead, don't we, in the current time.
We're all in the same boat in that regard. Certainly, is what will happen with our courts and how we're gonna resume regular or normal life. It should be interesting.
I was thinking what you were saying there, Kristina, because earlier, Leyza, you mentioned the interesting differences between UK and US, and I think one of the things as between Cayman and UK, which is fundamentally different from the United States, is the notion of, because you mentioned it, Kristina, solicitor barrister, where if you have American clients, this notion that you could have a QC, Queen's Counsel, has come in and argue some of the matters. That relationship and dynamic is just really different to what you see in the United States. I don't know what it is in Brazil, Flávia, if you guys have a similar arrangement.
How does it work in Brazil, Flávia, when you select the counsel for your cases?
This is one of the powers of the trustee, is to hire experts, but always after court approval. So the trustees can nominate these experts to help him, to supervise the debtor's activities or other issues in the organization. And to do so, we use criteria such as network specialism and the preview experience in similar cases. And we also are bound by the judge's approval all the time. And in liquidation, the experts have a broader area of work, especially when liquidation involves foreign assets, enterprises, cross-border insolvencies. In these cases, it will be necessary to hire foreign experts because in Brazil, I believe we have less experience, and we just adopted the model law. And in these cases, we need assistance to deal with these issues. And we have to hire experts to recognition of procedures in other countries and to look for the assets where they are located.
Excellent, excellent. Can you tell me, Flávia, one of the most interesting aspects of a case or a challenging case that you have been involved in?
Yes, and I would like to talk a little bit about the MMX case because I could work in the trustee office appointed in this case. And this case, we pay attention on to this case because the owner of the company was one of the richest men in Brazil, and he was about to lose it all. And MMX is an iron ore mining company which filed for reorganization in Brazil, in Minas Gerais, my state. And it had its plan approved in 2016 and attachment approved in 2018. And in 2017, the Brazilian court granted an order to pierce the corporate veil of the debtor to attach these assets, the assets of the controlling entities of the debtor, including Ike Batista, who owned the world's 7th largest fortune in the world, according to Forbes 2012. And in 2019, the Brazilian court entered an additional order to pierce the corporate veil of the debtor with the purpose of freezing and seizing assets of more 7 entities, up to the total amount of approximately 800 million reals, which was approximately $200 million. And these orders, it's interesting to mention that these orders were recognized by the United States Bankruptcy Court. And it's important to remember that in that time, Brazil was not signatory of the model law, but the United States allowed the recognition of Brazilian court ruling inside the Chapter 15 procedure. And it was very, very nice. And this case is an example of the court willingness to recognize foreign bankruptcy proceedings in the sense of an express reciprocal jurisdiction. This is a ongoing case, and it's interesting because piercing the corporate veil in Brazil is very common in liquidation, but not in reorganization. And in this case, however, the judge decided that the reorganization was used to commit fraud. And this fraud took different forms. First, the company disclosure false productive prospects announcing his intention to extract like 36 million tons of iron ore, but it was less than 7.7 million tons. And second, the false notice made the shares value increase a lot, and these shares were sold, and the money was distributed in a complex structure of offshores involving other companies and Ike's family. And this is, like I said, this is an ongoing case, but we expect that in the final judgment, the decision of liability will be maintained with full payment to the creditors involved.
Excellent, excellent. Thanks for that very interesting rundown on MMX. I'm definitely looking forward to seeing how your new law works when we have to have foreign proceedings recognized in Brazil. So that's one aspect of the new law that is exciting, I think. Tell us a little bit about an interesting case that you've worked on, Kristina.
Yeah, I thought I'd pick up here just to mention litigation funding, because it is now a key feature in asset recovery and enforcement. In the UK and obviously elsewhere, there are specialist litigation funding firms, and obviously it allows cases to be brought, or aspects of cases to be brought, that might not otherwise have previously been able to have been pursued. For example, where you have solicitors in jurisdictions that can't act on a contingency fee basis. And then obviously when you've got a litigation funder involved, they generally will only be paid when there's actually a successful recovery action and there's an outcome, and they'll be paid from realisations. So it's actually another tool in our armoury, in fact, that we are able to pursue claims if with the funding there. An example of a case that I had was an investment scam case, and one of the creditors was owed £5 million, so much smaller scales than Flávia was discussing, but I thought it's a good example just to show the effectiveness of litigation funding. And yeah, so it's an investment scam, and there are other creditors of over £25 million. So after protracted litigation from the creditor, a judgment was awarded in the creditor's favour. Unfortunately, it wasn't paid, the judgment, ultimately, so further action was required. So I was approached to be appointed as liquidator of the UK entity in the investment fraud. And so, as we've talked about the investigations that we do undertake, I call that sort of phase one of the gathering the books and records, looking at the bank statements, undertaking the forensic review. And actually during that exercise, I identified that funds had been transferred offshore, and then was able to recognise my appointment offshore to then obtain the bank statements there. And actually the information was invaluable because it identified further targets and the director's assets in other European countries. At that point, the creditor was getting litigation fatigue. Obviously, it had been going on for a long time. And that was a good point then to approach the litigation funder and various funders to look at what the best option was for the creditor, and then secure a funder. And it resulted in a favourable outcome for all involved.
Kristina, where offshore did that case take you? What jurisdiction?
Isle of Man, Spain, France.
Excellent, excellent. So what's your challenging story, Margot?
Well, I'm listening to Kristina, and you know, it's certainly interesting, the cases that end up being the catch me if you can type, where just it starts with somebody defrauding a creditor, and you pull on the initial thread wherever it's starting, if it's starting in Cayman or it's starting in the US, and then you follow the trail through bank account statements and discovery, and you find yourself going to England, and then maybe you're in Singapore, and then you're somewhere back in Switzerland, and so it's following the money trail, and I think you find they can range from small, a few $1 million to the hundreds of millions of dollars. In some ways, I'm just wondering out loud whether some of the much larger frauds tend to be a lot less complex, because you think of Madoff, for instance. Just kind of the bald-faced assertions and frauds that people can levy on someone just by making stuff up, versus the elaborate setting up structures in jurisdictions that are really difficult to get at information. And so it's the tension between those two, and litigation funding certainly has made it possible to do some of the kinds of cases that years ago you would have just had to pass on, because people were just too afraid of the complexity, or it kind of goes in the too hard bucket. And you've got a lot more sophisticated, investment funds and private equity funds that are interested in funding these opportunities, because if you have the stomach for it and you have the money and you're patient, you can really see some great recoveries at the end of the day, which is what you want. That you want to put money back in the hands of the people who it's been stolen from. So
in your opinion, where's the toughest to crack place around the world?
I'm sure most people in the offshore world would groan if they see, and I don't know in a world of diversity and inclusion if I'm allowed to call out the jurisdictions that are tough, but I think they're fairly well known. But like the Belize and Cook Islands, you know, some of the Vanuatu, some of those places are really difficult to get at. So you can, they're not, but it's much harder. So
Excellent. All right. So have you had? I think all of you have had multi-jurisdictional experience, and you've been involved in cross-border cases. How have you used your power to discover or find assets offshore? And I guess, Kristina, I'll start with you.
Okay. Yeah, as you say, I mean, I think we'd say the majority of matters now are multi-jurisdictional. It's the way of the world, isn't it? The world is much smaller and there's more money. It's easier to have fight your money assets all around the world. So just examples that I've come to mind that I've been involved in more recent times. So Chapter 15 recognition in the US and then disclosure thereafter was an effective power. A joint British Virgin Islands appointment, and when there was a property in London, to then be able to realise the property through there. An appointment over a UK entity where there's a worldwide fraud, and actually it requires other office holders in other jurisdictions to sort of combine efforts. I think office holders will have the same goal, see maximising realizations, and sometimes it is necessary and needed to work together for that common goal. Bringing proceedings in Spain, there was a time when in the UK a lot of Spanish property was being bought, so that still comes up fairly regularly as well. So they're just some examples there. How
about you, Margot? What do you think? What power as a fiduciary have you used to go outside of your jurisdiction?
I'd say more recently, or I guess it has always been a pretty effective power alongside when you're trying to get the information and you feel like you've got part of the picture. If you can do to fill in the gaps, the Norwich Pharmacal application to get access to service providers, banks who have information that you may need to round out the picture. And you may need that before you can go get a Mareva or a freezing order against the assets worldwide. I mean, that's very effective if you need to get your foot on it and hold the assets in place if there's a real risk of them dissipating and moving beyond your reach while you go through the process of making your claim and getting a court to decide on whether you're right or not. There's a pretty high threshold for those, but you know, in cases where there's fraud and people have been willfully kind of hiding their assets from creditors, those are a very effective tool. And as Kristina said, the Chapter 15, there's nothing like the power of the U.S. subpoena. It's pretty great. So I think you'll find a lot of offshore liquidators have you know, Chapter 15 recognition proceedings so that they can get the benefit of the stay of any actions and the ability to subpoena third parties. It was, I do remember the day when it was so much more difficult to do. You really sweated the Chapter 15 process, but you know, in current day, it's much more collaborative and jurisdictions understand the global nature of business and that you need to have some of these tools in place to get the job done effectively.
Excellent. How about in Brazil, Flávia? What is, as a fiduciary, your most effective tool to recover assets offshore?
In Brazil, under the Civil Code and the Bankruptcy Code, if the actions of one partner or managed cause deviation from company's purpose or result in committing of assets because of the abuse of the legal entity, the court may consider such partner or manager personal liable without limitation for the company's obligation in that. And this is exactly what happened in MMX. With the changes brought forward the new law, we don't have more of the possibility to extend the effects of bankruptcy to the management and other companies in liquidation. But we have the possibility to responsible the manager piercing the corporate veil. When the trustee and prosecutor or creditor or interested party verify commingling of assets among the legal personalities or their management, as well as the occurrence of asset misappropriation, they can request to the judge piercing the corporate veil and disregard their legal personality to collect personal assets. And like in the MMX case, when it happens, we can use this judgment to recognize in foreign countries and to look for the assets in other where they are located. It's interesting to mention that, like I said before, in Brazil, we don't have the provisional liquidation, but we have some tools that can be used. In some circumstances, particularly where companies or individuals participate in frauds, the trustee can use provisional measures to freeze the debtor assets. And of course, they have to ask to the judge, request to the judge to use these tools, but the government provides some tools like we call in Brazil Cisbajud, Simbajud, and other tools to locate the assets and to freeze these assets, avoiding the dissipation of them. And it's important to say that the word provisional is used, but the debtor has the right to contest, to be noticed, to be heard in a hearing, and the opportunity to say something, to defend themselves. But only after the provisional measures are taken, if the trustee could properly justify the measures, the provisional measures. So perhaps in Brazil, we don't act quickly as we need in the beginning of the bankruptcy case, but we have some tools available to freeze the assets and to avoid the dissipation of assets.
So that seems very powerful when you have a tool that makes the management who's done something wrong liable for all of the company's debts. That certainly sounds different than what we are able to do here in the United States generally. So it sounds pretty powerful. All right, so I want to have some time for questions. So if anyone in the audience who wishes to ask a question, you can start populating those into the chat. And I'd like to close with the question, my favorite question, which is, if you had to pick one of your superpowers as a office holder or trustee in each of your jurisdictions, what would that be? Let's start with Flávia. What's your superpower?
Is the piercing the corporate veil. And,
I would say so.
Yeah.
Pretty powerful. Pretty powerful.
Yeah.
How about you, Margot? What's your superpower?
It's like that question when your kids say, which one's your favorite? You're not supposed to have one. So I guess it's chapter 15. I'd say chapter 15 recognition tends to be a go-to in the cross-border cases. You kind of can't leave home without it.
Excellent. How about you, Kristina?
I would say it's that the UK court orders are widely recognisable worldwide. So if you can find the nexus in the UK, that can be a really strong and good starting point to then go around the world to trace the assets. I just wanted to add as well that I think Margot's obviously mentioned receiverships and Flávia as well. And we do have a court-appointed receivership appointment here as well, which is used in dispute situations to protect assets. So that, I guess, that is another superpower as well in the sort of non-insolvency sense, although it may well turn into insolvency.
All right. So we'll stand in for questions now. I don't see any populating just yet. Maybe we made all these points so clear no one has questions for us. But if not, I definitely have some questions. Anyone in the audience? We'll just give them a minute to populate those questions. In the meantime, Margot, how about you tell us about this Norwich Pharmacal and how that works? Because for those of us who are in the U.S. and perhaps in other jurisdictions that don't have Norwich Pharmacal, it'd be good to understand a bit about how that works.
Okay. Well, I think, and we've seen kind of more of an increase in Cayman of those type of applications, I'd say, in the last few years, because I think historically, Cayman has a confidential information preservation law. So there was always this notion that if you made a Norwich Pharmacal application and you were successful, that you'd have to turn around and actually then make that, well, that what would happen is if you were successful in obtaining it against a bank, the bank would claim, well, look, that's confidential information. So now I need the cover of the court to be able to share that information with you. So you'd find yourself embroiled in yet a second application to clarify that the party you were seeking information against, whether it was the registered office or a bank, could provide it. So there was a recent ruling where the judge made it very clear that when the NPO was being issued, you didn't then need to go get cover under the confidential information law, preservation law. So that certainly makes it easier there. And I think they're very similar to the United States. You have them as well, don't you, Leyza, in terms of
we don't have Norwich Pharmacal per se, but we do have requests for information not too dissimilar under various statutes. Obviously, in the Chapter 15, we have in the Chapter 15 realm, we have a pretty wide range of discovery that's available. But outside of a formal insolvency proceeding, we have 1782, which is under a federal law, which gives you the right to information, which is a good tool for office holders like yourselves. So we have a couple questions. One hailing from Canada. Here in Canada, judges take opinions of trustees very seriously and they rely on them. Do you find that to be the case in your jurisdiction? Kristina?
Yes, yes, they do. We're, as an insolvency practitioner and trustee in bankruptcy and liquidator wind up of the court, we're independent officers of the court. And so the court doesn't like you to keep going back for decisions. It doesn't want to be involved in such decisions. So I always find it really interesting in the different jurisdictions and different areas of law where the court really does get involved, like in trust law, where the court is receptive to kind of signing off. It's very much sort of the buck stops with us on a lot of decisions.
All right, so we have a question on from Rosa regarding Brazil, and she hears that in Brazil, the judges may very easily lift the corporate veil. And what type of evidence, Flávia, does the judge need to hear in order to lift the corporate veil?
The trustee has to prove that the partner or the manager caused deviation from company's purpose or result in committing of asset caused by the abuse of the legal entity. In this case, court may consider third partner or manager personal liable, but it's no simple like seems to be. You really have to prove to the judge that the partner or the manager is causing deviation from company's purpose and is committing in this or result in the committing of assets caused by the abuse of this legal entity.
Excellent. So it's not as easy as it sounds. There is a pretty high evidentiary burden. Okay, I got one more question. So we have 1 more minute. So this will be the last one. Have you got the enforcement of orders from your jurisdictions in the U.S. before starting a Chapter 15 case? This is a question coming to us from Solimar Castillo Morales in Puerto Rico. Enforcement of orders from your jurisdictions before there's a 15. Any one of you, I'll throw this up for any one of you who have you had enforcement of your orders before starting a 15?
Well, you mean enforcement of the orders in the sense that we have the appointment. There's been a proceeding started in Cayman before going to seek foreign representative status in the U.S., because you have to prove the connection and that for the decision of whether it's foreign main or foreign non-main. So in our cases, you're looking at where is their bank account, where's the activity, what's the nexus to the estate and its creditors, and which jurisdiction does it belong. So generally, if we've got one in Cayman, we have the basis on which to assert foreign main, and then we will make the application in the US, and it's similarly when you're looking for foreign representative status in Canada. Again, you know, if you've got the foreign proceeding is the main proceeding in Cayman, will then look to go into other jurisdictions, and you can now do it in Switzerland as well. Their change in their bankruptcy laws enable you to, you no longer have to start a mini bankruptcy. You can go in and make an application recognized. I know, Kristina, that works similarly across Europe as well.
Yeah.
So that's a recognition, that's a recognition or an enforcement of your order of appointment. How about an order that you've received with some kind of relief, like say a freeze order or something along those lines? Have you sought enforcement of those orders in jurisdictions like in the US as an example before starting a Chapter 15?
The process, from my experience, the process would normally be following the Chapter 15, because a lot of the proceedings will have been here or in other jurisdictions as well. So it really goes back to that strategy again. Actually, what are you trying to get the information and where from, and what's the easiest way? So across the jurisdictions, where can you get that information? Yeah,
that's been my experience as well, is the timing of your requests around the world matter, and what comes first and what comes next is key as well. So when you're acting in a role where you're finding assets, you have to make sure to know where you think you're going to be looking, and which jurisdiction comes first or next is an important strategy element in order to be successful. All right, this is it's the end of our presentation. Thank you everyone for joining us for the Women in the Forefront of Insolvency's first presentation of the series. We had a great time this afternoon discussing cross-border insolvency issues, and I look forward to seeing you all again in the next series presentation. Thank you again from IWIRC and III. Have a great afternoon or evening wherever you are. Thanks again.